Over the past year, we've seen strong opinions on the UK government's Employment Rights Act from all sides. On the one hand, it's been described as a landmark legislation dragging Britain's outdated employment laws into the 21st century. On the other, business groups are warning that if implementation goes wrong, these new rules could pose real risks to job creation and economic growth. Whatever your viewpoint, one thing is clear. This act is set to reshape the employer-employee relationship in a way we haven't seen for decades.
And that's today's topic, the Employment Rights Act. The Act represents the most significant shift in UK employment law in nearly 30 years, and there's a lot for businesses to get to grips with. Welcome to Business Talks, a podcast by Saffery. I'm Tom Alun-Jones, joined by my co-host, Zoe Thomas.
Hi everyone.
And given we're stepping outside our usual area of expertise today into some legal areas, we're joined by an employment law expert, Dan Begbie-Clench from Doyle Clayton.
Hello everyone.
Dan, before we get into the detail, can you tell our listeners a bit about your role at Doyle Clayton and how you're supporting clients navigating these kind of changes?
Yes, and thanks Tom and Zoe for inviting me on today. So I'm a partner at Doyle Clayton's London office, and we specialise in employment law, business immigration, and all related legal matters in the workplace. And at the moment, we're helping our employment clients prepare for the Employment Rights Act changes, and that includes a range of issues, but significantly having to rethink some long-established frameworks and considerations that employers have relied on for many years when it comes to dismissals. And we're also training HR teams and managers on probation and performance management and helping them to rework contracts and policies.
Grand. Thanks, Dan. Let's get into it, I guess. The Employment Rights Act brings a raft of major changes for employers to manage a variety of things, including unfair dismissal rules, qualifying periods, family leave rights, and other employer obligations. These changes have a sort of staggered timetable for introduction, with some provisions kicking in as early as April 26 or January 2027. Given the magnitude of these changes, it's obviously essential that businesses understand the risks and the opportunities that these reform brings. Dan, will you set the scene for listeners? Why has this legislation been introduced?
Well, it's partly been introduced because the Labour government campaigned on improving workers' rights and campaigned that they would introduce a raft of rights from day one of employment. It's also partly being introduced because some laws needed a little bit of updating, but I think it's safe to say that the main driver of the changes relates to Labour trying to, as it says, improve the lot of the working person, but also to ensure that the unions and other groups that supported it get some benefit for having thrown their weight behind this Labour government.
Interesting. But we also understand that there were some perceived kind of bad practices that some employers were doing, some of which people may have seen in the news. What types of things was this legislation introduced to battle against?
Well, there's certainly a drive from the government to do what it sees as improving job security, so certain changes to 0 hours contracts and so on, and ensuring that workers have protection from an earlier stage in employment. And some would say this is modernising some outdated employment protections. There's also an aim to improve transparency in the workplace and for workers to be treated better and to reduce instances of insecure work. But in some cases, you might also say that's going to make life much more difficult for employers as well, because there'll be more administration to deal with, more red tape, and certainly workers will have rights from an earlier stage, which is a very big difference in terms of how they're treated at the moment.
Interesting. And quite a lot of changes for employers to get their head around. Getting into, I guess, a little bit more of the specifics of it, Dan, can you outline some of the key measures that employers will need to be aware of?
So yes, I'll summarise a couple of the key measures. I think it's helpful to understand at the outset of this that the Employment Rights Act is an act of Parliament, and so it can't be easily changed by a new government. So if we do have a change of government in coming years, we might still be stuck with this legislation and state of play for quite some time after that. Often employment changes are brought in by regulations which are more easily changed when there's a new government in. But to amend this Act of Parliament will require a significant process through Parliament and also the government having a majority to do so. So first thing is that employers have to understand that these changes are likely to be with us for some time. So moving on to the key changes specifically, two of them focus on unfair dismissal. And the first is that the qualifying period for unfair dismissal is going to be reduced from 1st of January 2027. And that qualifying period is currently 2 years. So at the moment, and for a long time, employers have had up to 2 years to address issues with performance, to make a decision about whether somebody is the right fit in the role, and to then decide to terminate the employment if they think it's not working out, with relatively low risk and certainly no risk of an unfair dismissal claim within that 2-year period. But that qualifying period is going to be reduced to 6 months from the 1st of January next year. So anyone who has 6 months service as of that day and onwards is going to have an unfair dismissal claim. So what that means is, in practice, it's the shortest qualifying period that we'll have had for unfair dismissal since the 1970s. And it has been shorter. It was 1 year in the late 90s and 2000s, and it's been 2 years for around about 13 or 14 years now. And it means employers are going to have a shorter period in which they assess new hires and make a decision on whether or not to retain them. So that will bring probation periods sharply into focus, as well as performance management. So what that means is, if an employee passes the 6-month barrier, the employer will need a fair reason to dismiss them, and that's going to obviously increase employers' risk, because there will be a risk of claims at an earlier stage compared to now, and they will have to think about matters such as performance management in a way that they don't have to do within the current 2-year period. And it's important to remember also that dismissals includes not renewing a fixed term contract. So employers won't be able to use fixed term contracts for employees to get around these new unfair dismissal rules, because simply not renewing those contracts counts as a dismissal as well. The second significant change, and I think this might actually end up being the most important out of all of the changes being brought in by the Employment Rights Act, is the removal of the compensation cap, which is going to make high value unfair dismissal claims possible. And that's especially relevant for people earning over £100,000 or with valuable incentives or bonuses. And there's an interesting backstory on this change, in that it was never on the cards. It was never part of the original legislation put before Parliament, and it wasn't something that the government was talking about doing, and certainly something that the government did not consult business groups and other interested parties on. This change to remove the cap on compensation for unfair dismissal was brought in very late, indeed only in early December 2025, just as the bill was in its final passage through Parliament. And it seems to have been a concession from the government to unions and other groups who supported it, since the government gave in on the qualifying period for unfair dismissal. The government had wanted that to be a day one right, and then eventually had to concede on it only applying after 6 months. And in return, it seems the government gave this concession to unions, which is, we will remove the limit on compensation for unfair dismissal. Now, that has the potential to be a massive change, because we have always worked with a cap on compensation. It's been in place since the 1970s. And for a long time, it was a very modest limit. And it wasn't until around 1999 when it was increased to £50,000. And since then, it's increased a little bit each year and is now £118,000, or 1 year's pay, if that's a lower sum. So we've always had this cap to work within, and we've known what the limits are. And taking away that cap from the 1st of January next year is going to be significant, I think, for 3 reasons. Firstly, it means that well-paid employees will be able to claim ongoing loss of salary, bonus awards and incentives through an unfair dismissal claim, whereas at the moment there are constraints on the value of that claim for them. Secondly, it means a big change for how employers will have to think about things, because the cap meant certainty in the past. We had a long-established framework of risk management and commercial strategy, because an employer knew that the worst-case scenario would probably be a maximum award for unfair dismissal. But once that cap is removed, there will be a lot of uncertainty about how much claims are worth and whether you'll be able to settle them at an early point or at all. And the third significant factor is that that cap has actually meant there has been a limited amount of claims going through the tribunal system, especially from high earners, because frankly, for some of them, it wasn't worth it. They earned enough money that the maximum claim for unfair dismissal of £118,000 didn't really represent something they wanted to go after. Whereas from next year, it may be worth their while to threaten litigation and to pursue it because the possible rewards may be greater and certainly the risk for the employer may be greater as well. And the third set of significant changes coming in is that there is an expansion of family leave rights. So day one paternity and parental leave rights, for example, enhancing day one protections for workers. There will be changes around the edges of flexible working arrangements, ensuring that employers must give a reasonable rejection to any request, which arguably moves the needle a bit and imposes more burden on employers to justify their reasons for turning down a request for flexible working.
So that's quite a lot for employers to get to grips with, particularly given the level of sort of increased risk that you've kind of hinted at there with lower qualifying periods, the removal of the compensation cap, and that sort of requirement for less flexibility in terms of rejecting requests from working from home and things like that. We've obviously seen a lot of our clients moving towards less flexibility in the last kind of 6 to 12 months. I guess just to expand on those listening who are kind of employers and in that space, what are the timeline for these changes and kind of what's coming next in the process?
Well, there's an elongated timeline for these measures. And some of them, the dates for implementation of some of them have not yet been finalised. But we know that the unfair dismissal reforms will be effective from the 1st of January next year. And some of the other changes, such as the family leave rights, are coming in this April. An important point about the unfair dismissal compensation cap change is that whilst it's slated to come in from the 1st of January next year, we are not yet clear, because no commencement regulations have been issued by the government yet, whether that removal of the compensation cap will only be forward-facing, so for dismissals taking effect on or after the 1st of January next year, or whether it might also apply to dismissals that have already been made by that date and where claims are already underway in the tribunal. So that's one to keep an eye out for.
Okay, that is a sort of element of significant uncertainty around those key points, which I guess everyone's got to keep an eye out for, really. So far, we've outlined the background for these changes and some of the key changes from a legal perspective. We're now going to kind of move on and look at the practical here. What are the sort of potential unanticipated consequences for this legislation? We've talked around the rules, but how do we think businesses might respond?
Actually, Tom, I was just going to say, I suppose from what I've seen on the tax side of things, you've got the national minimum wage and the national living wage increasing again from the 1st of April. We've also got other additional changes in terms of national insurance that came in, and not this budget, the budget before. So I suppose that on top of this as well. Dan, are you hearing stuff kind of in conversations with your clients and on their views on this? Because it's quite significant changes in terms of the employer, isn't it?
Yes, I think that's right. I think there's a lot for employers to deal with, and I don't think many of them have fully grappled with the consequences of the unfair dismissal changes. Of course, we probably have the period for the rest of this year for employers to take action where they might have difficult situations with employees. And it may well be that the cost of doing that this year is lower than it might be once the cap is removed from 2027. But I think what the government is hoping for, which is an expansion of workers' rights and for more certainty for workers in the way in which they work and to have more protections, will create some of that, but it's also going to create a lot more uncertainty as well, and may even lead to employers restricting hiring decisions because they will have a much shorter period in which to make a decision about whether an employee is a good fit for the business. But certainly there's going to be behavioural shifts as employers need to adjust to the risks carrying out dismissals with uncapped compensation and where employees will have claims at an earlier stage. And I think a significant issue is going to be in relation to those high earner claims where previously it hadn't been so attractive for many high earners to pursue an unfair dismissal claim, but now it might well be once the cap is removed. And it certainly is going to upend a long-standing framework for risk management and decision-making that employers have relied on as part of exit processes, which will suddenly be taken away and arguably will give senior employees and high earners a much stronger position in the negotiation.
We've been talking fairly generally so far, which across legislation and rules that are changing for everyone. Are there any particular sectors or employee groups that will be more impacted than others?
Well, I think it's safe to say that in financial services, there will be more impact from the unfair dismissal changes because you have more employees earning larger amounts of money, whether it's salary or bonus or other incentives. And to date, they have been less incentivized to pursue unfair dismissal claims. And the changes from next year will mean that it will become more expensive and potentially a lot more complex for employers to dismiss somebody at senior level with low risk, and also facing the risk that those employees might then have substantial value claims for buyouts or other long-term incentives that they would lose as a result of the dismissal and might not be able to replicate somewhere else. And that's also going to be brought into sharper focus by the shortening of the qualifying period to 6 months, because that means that those employers will have a much shorter time in which to test someone and decide if they are a good fit for the role. And that's going to also place a lot of onus on employers to make sure they have a clear and well-documented process in terms of measuring expectations and making any decisions on the future of employment.
I think that's particularly interesting across our client base, where we're seeing obviously the heavy activity of private equity, so that kind of mergers and those benefits that may not apply to their next role. We obviously have a significant number of recruitment clients, so you've hinted at that a potential unintended consequence here of lower recruitment in the future due to this increased cost and risk. I guess if there's anything particularly on graduates or kind of early careers, because we've obviously seen in the news recently the impact of AI and technology and the difficulty of graduates finding jobs. Do you think this will have any impact on them at all?
It's certainly possible because of the shortened qualifying period for unfair dismissal. So we might see a more general reluctance both at junior and senior level from employers in terms of how easily they recruit and how quickly or otherwise they make those decisions on probation. I think whatever happens on those fronts, employers are going to be very well advised to make sure that they have updated any relevant policies on managing probation and managing performance, and also that the managers who are at the coalface of implementing these things on a day-to-day basis have been well trained as well, because the quality of decision making and record keeping is going to become paramount when employers have to defend these higher value unfair dismissal claims.
It's interesting you started on that topic. That was going to be my next question, which is, probably the thing that a lot of business owners are asking are, okay, what are the next steps we need to take to mitigate our risk, and what steps should we be taking now?
Well, it's always good advice as an employment lawyer to give to a client to say that your decision making should be well documented, fair, and properly resourced, because the more that you can show that you made a reasonable decision in the circumstances, the better chance you have of defending that if, in the worst case, you end up in the tribunal. So ensuring that managers are well trained on the new processes and that performance management does actually take place rather than problems being left to fester. Ensuring that any decision making on the future of employment is also well documented and properly considered as well. And I think it's key to ensure that regular appraisals are given to employees and that they are also given clear feedback, because one of the problems we see a lot is an employee who's underperforming and the company thinks so, but hasn't actually clearly communicated that to the employee. And then it comes as a bit of a surprise to the employee when they are given that harsher feedback about their performance being substandard. So you can even think about some training for managers on having those tough conversations to ensure that that feedback is clearly delivered. And certainly employers should be thinking about how they set expectations for employees, especially for new hires. So ensuring job descriptions are up to date and relevant targets and expectations are clearly set to them as well. And in addition to that, employers should be looking at their employment contracts around notice periods, probation clauses, pay in lieu of notice, any other flexibility terms as well, and ensuring that policies on probation and performance management are updated as well.
That's particularly interesting on the basis that some of our clients might be on the sort of smaller end and therefore may not have HR professionals with either capacity or even the experience of going through this kind of thing. They might be wearing multiple hats. So it does seem there's a significant amount of risk here, particularly for our smaller clients who may not have large HR teams to navigate those recommendations that you've suggested. We should probably start to wrap things up, as I think we've given everyone quite a lot to digest. Dan and Zoe, do you have any final thoughts before we close up for today?
No, I was just going to say as a quick reminder that I suppose we've talked about a lot today and Dan has given a lot of information, but it obviously doesn't constitute any legal, tax or HR advice. So it's worth reminding our listeners that they should get the right professional guidance before making any of those important decisions.
Great, thank you. Dan?
The one point I'd add is that I agree fully, Tom, with what you've said, that for small employers, this looks like it's going to impose quite a significant burden. And certainly the cost and risk of getting things wrong in the future is going to be substantial for smaller employers. So I'd always encourage them to take a proactive approach to performance management and setting expectations rather than a reactive approach, and certainly ensuring that decisions and conversations are properly documented so that you have those to rely on in the cold light of day in future if you're being asked to defend your decision further down the line.
Right. I think we're all done for today's look at the Employment Rights Act. A big thank you to Zoe and Dan for sharing their thoughts. Definitely a lot for businesses to think about as these changes start to roll in. If anything we've talked about raises questions for you or your organisation during any reviewing processes or actioning any of the recommendations that Dan gave us, please feel free to reach any of us, Zoe, Tom or Dan. And you can always find more insights at saffery.com or I'm sure Doyle Clayton's website as well. If you'd enjoyed this episode, please subscribe on your favourite podcast platform and maybe even leave us a review. Thank you for listening and we'll see you next time.